You are Frankie Farias. Mr. Farias, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for the, he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. Is this how you understand this agreement?
I'm sorry.
You have two agreements on both of your cases. On the DWI, they've offered you 3 days in jail, credit for the 5 days that you've done. But you need to understand that that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record. They're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term. So you need to understand, if you don't understand what a firearm is or what a weapon is, you need to talk to a lawyer because that's one of the conditions. Do you understand? When you pick up criminal cases, there are a lot of collateral consequences, as you now see. It can impact you in ways that you never, ever see. That's why you need to strive to never pick up any kind of cases. And when you pick up multiple successive cases, it kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. That's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. You understand? For you to complete this successfully, you have to do a batterers intervention prevention program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to one time a week for 8. You don't have to do this. You can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Have an attitude, Judge, is just, I mean, I understand, I messed up. I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and gumdrops?
No, I didn't think that. I'm just, it's just.
And here's the thing, though, Mr. Farias, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
It's a conversation.
No, but Nathan, I want him. How did we treat you in what way?
I mean, I'm not saying y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20. I made a mistake. I was drinking. It was just a mistake.
please do not admit to committing the offense if we actually haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but,
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
But I didn't assault nobody, but I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, I don't, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it. You know,
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
well, hold on a second. How old is the case? I mean, the case is from
The-
it's 510 days old. No, we set the case for trial today.
We'll do
That's
that.
it. And I'm not here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand the way I talk to you now is in hopes that you don't pick anything up in the future, because
I haven't.
you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every
sure you do.
single-
But I'm the one that I am one of those persons that means it when he says it.
I'm gonna hit the pause button.
You pick up a case in 2020 and now you pick up a case in 2023.
I'm gonna hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you, but what you're pleading guilty
No,
to carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today and get convicted, which is what you're planning on doing, the second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we,
Oh,
Yeah,
I'll just set
okay.
it today because it'll be long enough that we can have a conversation. Almost
So-
30 or so days, Judge.
Yeah. November 19th.
That's
That's,
fine.
it's over 30 days.
Yeah.
Okay.
It's not that, it's just that I don't remember when Thanksgiving is, which is a week or two after that, so we're fine.
It's that Tuesday. So it's the Tuesday before.
Tuesday, the week before,
Correct.
we're fine.
Okay. 11/19 it is on both cases.
Is Ramona in the back? Do I need to go talk to her?
Yes. No. Well, I'll tell them, but don't let
Oh,
him leave.
Nathan, you're fine. It's a good day.
Ramona.
You're welcome.
Who said my name? Yeah.
This is Mr. Wiley, another plea, Your Honor.
Good morning, Mr. Wiley.
Good morning, sir.
Mr. Wiley, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in Harris County Jail. How much credit does he have?
71 days.
71 days credit that you already have. You're giving up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. It will go on your record and you can't take it off. Is this what you want to do?
Yes, sir.
You need to also understand, Mr. Wiles, that from now on, you will be facing a minimum of 90 days in jail for any cases that you pick up. Do you understand?
Dealing with the same exact.
If you pick up cases in the future, it's a minimum of 90 days in jail. Is this what you want to do? How do you plead to the offense, sir? I will find you guilty, sentence you to 3 days in jail, give you credit for the 71 days you've done. I will roll your car costs, you won't owe anything, and good luck to you, sir. Thanks.
Go to Ms. Ramirez.
Absolutely.
Follow the recommendation of the probation department. Either feels A, she's reached a point where they can no longer help her and she needs a higher level of care than the probation department can be. If the probation department feels that they can still treat her, we follow the recommendation of the probation department. Me being,
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, 2 to 3 times a week. So
I
if
told her last time we were here.
now when we approached, because I was with her, Judge.
I told
No, I
her.
was with her and I don't remember you saying that.
I told her what you need to have done, and then this is what you registered for. When you come back, this is what we're gonna end up doing. Regardless, look, regardless.
What I'm saying is, since the probation department feels that they can help her, if she can register to one of the 3, and I'm gonna bring her up here with, if you decide to allow her to continue, I'm gonna bring her up here and we all talk, so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's childish because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
this is all
It's,
predicated on if the court does not rescind its order for supervision.
what I'm gonna do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that. And then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying,
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage I don't think that this is right. And I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now is not what this program is designed to do. And it really violates the spirit because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world. And you've done everything against that. I mean, for you to sign up for the class 1 day before court, it hurts and it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, 2 weeks, not 3 weeks, 4. So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately set your case for trial. You have 1 week to sign up for the class that's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program 3 times, IOP 3 times a week. What are the requirements? Is SOP once a week or, okay, right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to have, right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about, exactly a week.
Okay,
from
do I
today.
have it
Next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay,
State has nothing further, Judge, for the court.
See you in a week.
thank you, Judge.
Thank you. Katrina Rasul. Morning.
Good morning.
Ma'am, you were wanted out of the state of North Carolina for felony probation violation, 4 counts as alleged. Are you waiving formal extradition, ma'am? Okay, we wish you the best of luck.
Thank you.
Thank you.
What's the last name?
Colin,
Yes, Your Honor.
hey, you're still here.
Yes, Judge, I had to come back. So I have Sarah on your docket today. It's got a little bit of moss on it, but I subbed
No,
in.
it's okay. It's only 100.
The court just asked me to approach about waiving her appearance on
It's
it.
okay, yeah.
Cool. I don't think we're there yet, Judge. They just,
Is this-
Brady notice that I got. It's,
Is there more discovery that's outstanding?
No, Judge, I think everything's in. I've already requested the Brady material, so we should be getting that in soon.
Is there nothing that you need me to sign?
I'm sorry?
No? Okay, got it.
I don't think
Okay.
they've got that for you
Give
yet.
you 30 days. It's getting up there, but after that point, we're gonna get close to, okay? Okay,
Thank you.
have fun. You ready?
Yes, Chair, wait on the docket today, Judge.
Hey,
Christopher, I'm sorry, Christopher.
I'm Bonner in jail.
Request. but-
Okay, there we go.
Personnel file.
I'll just
Okay.
ask him for a 30-day reset. It's gonna get dismissed once he takes the gun case.
It's 227 days old. Today was plea or trial.
Right, we don't need to
Yeah.
say, they just offered me right now a gun case and forfeit the weapon. So I'm sure he'll take the gun case within a couple of weeks.
Is Mr. Caraway here?
Yes, sir.
Can you bring him up, please?
Absolutely, Judge.
Come up, Mr. Caraway. So
He doesn't know about it. I just got the deal, so he's gonna know.
I'm not, it's 230 days old, man. It's really, really old. I want you to understand, today was the day that you were set for either plea or trial. What that means is that you're supposed to either accept a plea bargain or you're going to be set for trial. Your lawyer, amazingly so, was able to work out a dismissal now if you take a gun class and you forfeit the weapon. If that's something that you want to do, you need to commit to that now. And I'm going to set you 2 weeks to get that done. If you don't get it done in 2 weeks, you're out of time. By then it's over 250 days. I'm not going to do anything else and you'll get a quick trial setting. Do you understand?
Yes, sir.
Okay, I'd like for you to talk to it, Mr. Reyes. You tell me if you want to accept it. If you do, you got 2 weeks. You got to get that class done within that time. You get no more. Do you understand? All right, done. 2 weeks. You're out of time after that. Okay.
Thank you, Judge.
Mr. Lindsay,
Yes, sir.
I need your help on this.
Sure, Judge.
Please, if you don't mind.
Like you just need on safety.
We're talking about Carol Ramirez.
Here, this is not good news for me.
Let me tell you at the outset that I'm very upset, disappointed with the way that she's handled things. And
She being the
the defendant.
alleged. Yes, Judge?
So what happened was she gets into a DWI PTI program. While she's in the program, she basically just continues to party, essentially. I think she's using marijuana, she's using alcohol, she blows positive on the devices.
What I remember, Judge, and I could be wrong, but what I remember is that there was one positive for alcohol. I'm gonna pull up the email.
No, there's more. There's more than that.
And then the probation officer asked her about it. She said she had about 10 years celebrating her sister's birthday.
That's the positive that I know,
How
but
many
it just took a
positive?
long time. But it was the same day, the same, right? I'm sorry, Judge, I didn't mean to interrupt you.
It's okay.
Yes, it looks like it was only for one on July 21st.
That's the entire time? And you said, did she have a device the whole time or no?
She did have a device the whole time.
Okay,
She's on a scram and an in-car right now.
now she is.
Yeah.
She didn't have that before.
No.
Well, it doesn't seem like PTI is going too well for the young lady, Judge. I don't see the bond violation report. I don't know if I have access
No, it
to them or
wasn't.
not.
No, they
It's
weren't.
not, because she's in the PTI program, we're not gonna get the traditional bond violation that you would normally get with the email and everything. They just do the BVRs through here. And then what happens is they bring them back to court here. And then we typically admonish them, have some kind of agreement going forward or whatnot. So the idea was this, is that we amended the agreement. She was to do 3 days as a condition.
She did.
Right, she did. And then she was immediately going to apply for the IOP and SOP, and then she'd be out of the program, right, and complete it successfully. 4 weeks later, she just now signed up for the IOP. Was it yesterday?
Yes, sir.
When she was supposed to do it 4 weeks ago, right? And she was supposed,
But she did get her scram device, Judge. She went and she got her scram device, which costs a lot of money. She had that done. It's on her ankle. I'm not trying to justify her not complying with the IOP SOP.
here's my next issue. One of the positives, we sent her for a drug test. Now she's negative. My issue now is that it's not supposed to be
The
like
SOP
that.
is 30 days.
And it's not supposed to be like that. IOP, it's designed to be 3 times a week because that's what makes it intensive, right? The intensive portion of it in the spirit of doing IOP is that it's done 3 times a week in rapid succession. And it's done like that for like a month or a month and a half. And that's why it's intensive. So it's that she signed up for a class that's 1 time a week for 4 months.
Judge, to her defense, she was given a list. And I'm like, no, I don't want to offend anybody.
You're not, we have thick skin. You're not going to offend anyone.
She was given a list and she was told, call from this list and schedule. So I don't remember if she was told that she had to pick one with 3 times a week. I'm not aware of. I know that IOP is 90 days and I know that she has to go multiple times a week, but I don't remember her being told that she needs to pick one, which is, I'm not trying to excuse, nothing I can say changes the fact that she registered the day before court. But I don't remember her being told that she has to pick this one.
She gets TRAS and then they tell you.
I don't know any, I'm not present for those. So that's why I'm saying I don't remember anything. I don't know if she was admonished by her regular probation officer or if you.
Bottom line, Andrea, this is not going to work. It defeats the entire spirit of doing IOP because that's even at a slower pace than what SOP would be. SOP does even more so than what this.
Well, Judge, so she spent a lot of money getting that ankle monitor on. They're super expensive. I'm hoping that, and again, I have nothing to say to the fact that she waited until yesterday, but she did register. She set for orientation. If she swaps to a place that does it, so she does orientation, she starts, and we bring her back in 2 weeks, already registered, already orientation done on a place that does it 3 times a week. I would hate for her to be on the whole, hundreds of dollars for getting the ankle monitor on, thinking that she's going to continue on the PTI.
The problem is that I can't trust her to take the scram off, right?
But she's never done anything to temper with anything. She's never not comply when she had the interlock on.
She's all the time failed to comply, all the time.
She's had one positive for alcohol, but in terms of the device, because you said my understanding is that you have concerns that she would tamper with the ankle monitor, right? Is that what you're saying, or am I understanding you wrong?
I have concerns that she would use.
Leave the ankle monitor on. It's costing her a lot of money to have the ankle monitor on and the in-car, and these classes are not cheap. So it's a lot, it's costing a lot.
Andrea, normally, I would pay for it if I could.
I know, and we tried. Right, and I emailed Beetle, and it's not something that they do, and I understand that if they do it for her, then where do we draw the line? So we tried, but she's at a point.
I'm trying to tell you.
I'm sorry.
No, it's okay.
And it's okay. And
ultimately, it's your decision. We can talk about how we want.
No.
Mr. Lindsay, what I'm trying to tell you now is that in the current state of things, IOP being 1 time a week, it's not acceptable. And I'm not prepared to do a reset for 1 time a week as IOP.
Well, then let's change it. Let's bring her back in a week or 2. And at that point, Judge, if she's not registered where she has to be, then I'm not even going to open my mouth. I'm going to shut up and I'm not going to say anything.
You have to say, because
this case originally filed in 2022. This case lingered. It seems to me that the case went on for a little while before she actually entered PTI. Prior to going in PTI, it seemed like she had some issues with the court.
What issues?
Well, there was something in here. I think she had a medical issue with strep, so she didn't appear.
Right, she was sick, but
there's some bond violation. I don't know if there was or not, but it looked like she was set for bond forfeiture on 1 day previous. out of this court, I don't know what resulting, but the bottom line is now, since entering PTI, it seems that there's still been continued issues. And now here we are.
What issue? She only tested positive for alcohol once.
She got a scram device.
Yes. So she has it. That's the thing. Like judge ordered her to, she went to jail for 3 days. She was in jail for 3 days when we amended the conditions for the PTIs. And then when she came out, judge said she wants her to have both the scram and the in-car. So now she has both devices.
Did she ever have any bond violations while she was on bond?
I would hate for her to get kicked out with all the money.
243
She's not-
0612.
I get where you and judge is coming from. I'm just
Let me ask you, do you think it's in our best interest to continue?
spent all this money to get
Guys,
income on her.
Mr. Lindsay, I don't know if we're gonna go forward, but if we do, I'm literally going to bring her back on a bi-weekly basis to make sure that she's in compliance. I'm not gonna sit here and just continue to spoon feed this thing every 4 months to make sure it gets done. I mean, every 4 weeks, I'm not doing it.
I agree with you, Judge. I'd like to reach out to the manager of the program to make a recommendation to that individual and go from there. My personal thoughts are that this is a very old case. This case has had issues and has continued to have issues. The purpose of this program are for individuals to get their life back together. If that's not going to happen, then I think it just does the alleged defendant a disservice to keep her on a program that she's not going to make. To be my personal, it doesn't do the court any justice. It drains her of money, right? Financially, it keeps her on a docket for the court to belabor and continue to supervise. So that my position is that we probably terminate PTI, reset the case, set up a trial, or work it out. But that is not up to me. I'd like to highlight to the court.
But no, but it is. It's your program. It's not mine.
When I said me, I didn't mean the state of Texas, Judge. I meant me as like the individual George Lindsay. I'd like to, if I could take a leave of the court for 20 minutes, make a phone call,
I mean, there's
and
no,
see where we stand on this, Judge. If the court allow me a motion to leave.
I'll
Can I
wait.
run to another court and come back? Or are you guys almost done with docket, or should I
No,
hang
I
tight? You
mean,
tell
we
me.
probably have another at least 30 minutes, at least.
Well, I can email you. Let me-
Okay.
I mean, she's here now. There's no sense in delaying the inevitable.
I don't want to.
Right.
And I don't want to. I'm looking to get a resolution.
Okay.
But
I'll
I
hang
need
tight.
to,
I'll
I need to
just wait
decide
for
what
you.
our
Indra,
position.
Indra, at some point, there's got to be accountability.
I get
And when
it.
you come back here and you sign up the day before and you do the wrong thing yet again,
I don't disagree with you, Judge. I get where you're coming from. I get where he's coming from. I'm just trying
we
to,
also appreciate your zealous advocacy, right? Because I get it.
getting me anywhere, but
2 years later, you're still in it. There's a lot to say for that, right?
That's exactly what, and it's,
At some point, we got to cut the cord. Let me know.
hang tight.
give me 5 minutes.
Okay,
Give me a call. I'll be right back.
thank you.
Yeah, sure.
Okay, thanks. Okay. Claudius.
Yeah, it is. Two cases. Time served on the
All right, Judge, page 6,
Let's
Della
roll.
Cruz, come on up.
Who's here on the walkthrough? You said a lawyer was here?
JL.
They're coming back.
Okay. So Maria de la Cruz, good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On September 8th, 2024, an officer was dispatched to a target in Harrison, Texas regarding a theft. Upon arrival, the officer met with the complainant, the loss prevention manager, who advised the defendant had stolen from the business. The complainant advised that the defendant had entered the business with no merchandise and with a small pink fanny pack on her person. The defendant was then observed going to the style department and began making selections at the merchandise and then began going into the business fitting room. The defendant exited the fitting room and the style merchandise was not seen, and the defendant dumped the merchandise on the rack in the fitting room. The defendant was then observed going to the jewelry department, and the complainant advised the defendant was observed quickly selecting Kendra Scott jewelry, and the defendant went to the beauty department and was advised that she began selecting Kendra Scott jewelry and hair care department merchandise. And the defendant then went to the home department and then the chemical aisle and began concealing merchandise into the small pink fanny pack and began walking towards the front of the store. The defendant passed all points of sale without rendering payment for the items and the total amount taken was approximately, or was $103.92
Okay, where did you say this is from?
at Target.
Got it. Okay. Ms. De La Cruz, I'm gonna find that there's probable cause to go forward with your case. How old are you, ma'am?
19.
What do you do for a living?
I go to school,
Where do you go to school?
Pima Medical Institute.
Okay. Are you working as well?
Not currently.
Who do you live with?
My parents.
Are they here today with you? Okay. Like I said, I'm gonna find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Target stores whatsoever. You were given a free bond, so we let you out of jail. And that's how you're here before me. You're not gonna get another one. If you pick up a new case, if you go to any Target or do something you're not supposed to, I will revoke the bond, put you in jail. You will not get any more PR bonds, and it's gonna go way higher than it is now. Do you understand? Did you want to apply for a court-appointed lawyer, ma'am? Okay, we will give you an application. I'm gonna have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions though, okay? First, we're gonna have you sign a reset, and then we need to give you an application for an appointed lawyer. I need to know everything about you, and then we'll have you take a seat in the jury box. Please. State, nope. Anytime someone is monitored, like a DWI or an assault where we're gonna monitor with a GPS, then they would go to you. Here, just please, no going to any Target. Yeah.
Page 11.
Good morning, Mr. Javed.
Good morning.
Sir, you're charged with terroristic threat or a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 8th, 2024, in Harris County, Texas, an officer was dispatched to meet with a firefighter at 3515, a residence in Harris County, Texas. The officer met with the complainant, who stated she got into an argument with her husband, the defendant. The complainant stated the defendant had been threatening to kill the complainant's family in Pakistan and to kill her in the past. In 2023, she called the police, but no report was made because she was afraid of retaliation. The complainant stated they have talked about who the defendant knows in Pakistan and believed the defendant could do something to her family to have them killed. The complainant stated the defendant made these threats to her and her family to control her. When the complainant called for police on October 8th, the defendant told the complainant if she called the police, the complainant knew the consequences, while making a circle in his hands, gesturing as if to strangle the complainant.
So there's also felony retaliation.
Yes, Your Honor.
Is this within what you just said now, or is it something else that happened? Because I know it arises out of the same, but was there any more overt action that was done other than spoken word?
All right, Your Honor, let me check the DIMS.
Mr. Javed, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Yes, yes,
Okay.
sir.
I'm ordering you as a condition of your bond not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I'm entering in, or it looks like a protective order has already been issued on the 9th of this month. I would get to know it. If you do something to violate this protective order, the state can and will file additional charges as violation of protective order. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on a no contact order, I can hold you at zero bond. And I will do it in a second to protect every person of Harris County. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. Phone calls, text messages, social media, use of another person to relay any information. I'm also ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If you violate these conditions, I will revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. And I'm telling you now, I'm going to make it high. So no contact of any kind.
Your Honor, appears to be just the verbal threats.
Okay. So can you file no contact and no weapons, please?
Yes, Your Honor.
For now, I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign the bond conditions, and then we'll have you wait for your lawyer. Okay? Please. Mr. DeToto, do you have an arraignment? No? Okay.
You bone? All right, Judge Case 19, Perkins, come on up.
Silence all cell phones.
Good morning, Ms. Perkins. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 9th, 2024, officers were dispatched to 5299 West Park Drive in Harris County, Texas, regarding a major crash. The will witness stated he saw the defendant get out of the driver's seat of her motor vehicle and Houston Fire Department advised the defendant admitted to drinking. The officers observed the defendant with slurred speech and glassy eyes. Standard field sobriety tests were conducted. HGN was 6 out of 6, walk and turn was 3 out of 8, and one leg stand was 2 out of 4. The DIC was read and the defendant consented to breath. The results were 0.153 and 0.157.
Tell me about the driving facts again, please.
There was a major crash, Your Honor.
Okay, so she's at a crash.
She's at a crash, and then the real witness who was involved in the crash saw the defendant get out of the driver's side.
Got it. Okay. Ms. Perkins, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? Can you run her license, please?
Yes, Your
And
Honor.
also, does she have any prior DWIs, please? If you
No
can run
prior
her
DWI
license.
and license eligible.
Okay, ma'am, I'm going to find, like I said, there's probable cause to go forward. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. I'm going to revoke your bond. You will not get any more PR bonds. Do you understand? How old are you, ma'am? You're 20. What do you do for a living? Where do you work? Bombshells. Who do you live with? No, with mom, dad, or by yourself? Okay. Can you afford a lawyer? How much money do you make a month? Okay. Is that all you're doing now, or are you doing anything else in school or anything? Okay, I'll have you to fill out an application for me for an appointed lawyer, and I'll take a look at it. If you qualify, I'll provide you with a lawyer today. For now, I'm gonna have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box while you fill out the application, then I'll take a look at it, okay? You will need to meet with the pre-trial for your bond conditions, so don't leave until you do that, okay? Please. You have an arraignment. Are you ready?
I do.
We have to do it right.
Yeah.
Whenever you're ready.
Does we have another arrangement?
You want to do Corey's first, or? Yeah.
Oh, who was it?
Cubone.
Oh, that's the one else.
Is it Cubone?
It's fresh.
I'm not exactly sure how to pronounce it.
How do we pronounce your name, ma'am? Cubone. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Yes, Judge. On September 18, 2024, the officer was dispatched to a Walmart in reference to a theft in Harris County, Texas. The officer made contact with the loss prevention manager, who stated he followed the defendant in pink nurse scrubs within the business as she was pushing a shopping cart and concealing in a black backpack several items she took from the shelves of the business. The defendant observed the defendant pay for the items in the cart at the self-checkout, pass all points of sale, and exit without paying for the items she had loaded in the backpack. The complainant stopped the defendant outside the exit doors and confronted her about the concealed items. The defendant initially denied everything, but ultimately gave her the backpack, to which the defendant found unpaid items with a value of $118.53. Another unpaid item of a value of $1.38 was found wrapped in a Walmart plastic bag in the shopping cart. The total amount taken was $119.91.
Okay. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen? You are? Okay, I am ordering you as a condition of your bond not to go back to any Walmart. If we find that you go back to Walmart, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand? Okay. You have a lawyer. Because you have a lawyer, I will waive your appearance. So you don't have to come to court until he tells you that your presence is needed. But you must stay in contact with Corey. If he tells me he can't get a hold of you because you're ducking and dodging phone calls, that's it. We will revoke your bond, okay? Any questions? Yeah, I know. I have to apprise you.
I understand, yeah.
Do you have any questions? Okay, we're gonna have you sign a reset. After that, we'll have you take a seat in the jury box. We get your bond condition. We'll have you sign it, and then you're free to go. Okay? Thanks, Corey. No going to Walmart. No, she has a license and insurance, so she can drive, but just no drugs, no alcohol, random UAs. So you got subbed out of the Padilla thing.
Yes.
He's supposed to be here today too.
Oh, excellent.
So
Yeah, that's what
I told counsel yesterday that, I mean, we told you guys that the minute he got out of ICE custody, he was supposed to be here, and a month rolls by and he's not even here. And then counsel comes and says he's in like Alabama or somewhere else working. And I was like, that's unacceptable. He needs to be here today. Otherwise I'm revoking the bond.
Of course, Your Honor. I mean,
So yeah, don't worry about it.
we were willing to do the case pro bono.
Okay, not a problem. But if he's not here today, then, and as a matter of fact, did Padilla check in? Page 8, bottom of 18? No? Okay, if he's not here, then 5001. Yeah, okay, take care. Okay, counsel, you ready? Hey, good morning, of course.
I have a plea.
On Reyes?
Yes, sir.
Okay, I'm ready when you are. We're done with arraignments. Jose Vicente Reyes, do you need a translator?
No, sir. And it is no, it says 3 days Harris County Jail. I spoke with the state. It is a time, sir.
All right, good morning, Mr. Reyes. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. It's even there after you die. And this is important because you ever get pulled over and an officer's going to see this. If they smell alcohol or dope, what do you think they're going to do? What we're doing today, the proverbial slap on the wrist, now you'll be facing a minimum of 90 days in jail. So be careful because this time served, you understand. I mean, it's a minimum of 90 from now on. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, or possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. It will go on your record. It'll be there forever. Is this what you want to do?
Sir.
How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty and I will sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I have to suspend your license, so I will suspend it for 90 days. Do not drive until you get a license, and good luck to you, sir.
Judge, I asked that his license not be suspended. It's been suspended for over 220 days already.
I have to suspend it, right? If you want credit for the ALR suspension.
Yes, sir.
Why has it been suspended for so long?
I am not very sure. He just spoke. I'm filling in for Attorney Clay today, Eric Clay. So I just spoke to the client about the suspension.
Part of my PR bond was not to drive, and you revoked my privilege to drive. So I've been.
Well, there's a reason. Usually, if you don't have a license, you don't have insurance.
Over a 0.15.
No, I never take someone's. Has to have been an aggravating factor as to why. I don't just willy-nilly take someone's ability to drive away because I take it really seriously. You know, if you're driving in a manner like going over 100 or a prior DWI or with an open container or something like that. What happened in this case?
So in this case, officers were dispatched to a crash in Harris County, Texas, and they arrived and observed the vehicle with front end damage that had hit an apartment complex entrance gate and wall building.
You have a license.
I had a license, valid license and valid liability.
See.
Part of my bond was, just suspended my license. I couldn't drive.
Oh, you know what it was? You had an ALR suspension. That's one. Your license was suspended. Have you paid any kind of reinstatement fees? Then your license is suspended now. Whenever you get a DWI, you have 2 cases against you. You have this case, you also have an administrative case versus DPS. And if you don't take care of the administrative case, DPS suspends your license and it remains in suspension until you go and actively take care of it to have it reinstated. One of those things that you have to do is pay a reinstatement fee of around $125. So until you do that, it remains effectively suspended indefinitely until you take care of it. What we do is we bring you back in to apprise you of the fact that your license does become suspended and that if you drive, you're in violation of these bond conditions. So I'm trying to help you, believe it or not. You know, I'm not. So do this. Go get your license reinstated. Go to DPS. Show me that you've got it reinstated. Then we can run so that I'll give you credit for the time that you've had your ALR suspension. I'd rather have you driving legally than driving illegally, right? So go get it reinstated because what we need are the dates of suspension for the ALR. If you have that, we can give it to them and give you the credit. But don't just start driving now. Your license is still suspended. Alex, can you run it? You mind?
Yes, Your Honor, it's not eligible. And the most recent we have is the ALR suspension.
See, it's the administrative license revocation suspension that you get from DPS. You got to go call DPS and they'll tell you what to do to get it reinstated. All right.
Thank you, Judge.
Okay, guys.
Thank you.
Please. Hey, good morning.
2 cases on your docket this morning. The first one is Mr. Chason Booker. Mr. Booker has a DWI pending in this court under a .15 which was picked up roughly a month before this one. We still do not have any information back on that Del Rio case. I have reached out to defense counsel, and I know the state has also reached out to the Del Rio DA's office. It is what it is.
It's only 80 days old, so.
Exactly. It's a New York case. What I did want to ask you, Your Honor, Mr. Booker is currently under a GPS monitor, curfew, and also no driving. His ALR suspension from Del Rio, his Houston ALR suspension was recently dismissed, but he is still not driving. I wanted to approach the court in regard to the curfew and the GPS monitor. He is a 25-year-old man who has to be home by 9 o'clock. Can we dispense with the curfew and perhaps limit any no contact with establishments that serve alcohol, just so he can maybe have a little bit more life? He's not driving. He's not a danger.
He had a life and now he has 2 DWIs.
Understood, Your Honor.
Let him out in the middle of the night.
Understood.
Mr.
He won't
Booker.
be driving. He's not here today. His appearance was waived.
Yeah, I'm not gonna do anything unless he's here so I can talk to him, number one. Number two, why does he want to be out in the middle of the night?
He doesn't necessarily want to be out in the middle of the night, Judge, but if he wants to go out on a date or he's got to be home by 9 o'clock, it's just, it's.
I mean, I'll give you reasonable, okay? I want to talk to him about it though.
Okay,
I'll give you
okay.
10:30, but because he wants to go on a date when he's got 2 DWIs, that just,
Judge, it's been 90 days. I just wanted to see
I
if
get
maybe
it.
we could dispense with that as long as he wasn't.
regardless, I'm not letting him out in the middle of the night. I don't trust him with 2 up in DWIs.
Understood.
Anyway, but I need to know what he's doing in life
Okay,
now. If he's
okay.
still partying, no. I mean, I don't trust him with 2 up in
Understood.
DWIs in my.
And the second question I had was, I know that we once modified his curfew so that he could go move out of his apartment. He needs to make one more run to Del Rio the weekend of October 25th, and I wanted to.
I don't have any travel restrictions.
Okay.
So there, I mean, he can go wherever he wants. There's no travel
He
restrictions.
needs to be in by 9 o'clock,
I don't want him out in the middle of the night. I just,
and we can't just extend it until midnight.
no.
Okay, all right.
No. What does he want to do till midnight?
I think it's just to go be able to go take a day out, Judge, and not have.
Go out and
to, like,
party and
take a woman out to dinner. He's a 25-year-old man, attempting to have relationships with ladies, and it's difficult when you have to tell them you turn into a husband. I mean, he's innocent until proven guilty.
I get it, but I don't want a third one. He's got 2 DWIs in 2 pending counties. What, he's gonna go out. What do you do when you go out on a date?
Yeah.
You know, you go out, you have a nice bottle of wine, steak dinner. I mean, we know what happens when you go out on a date. The peer pressure to drink when you're out on a date is going to be tremendous because you know she might partake in that too. No, I never said he couldn't date. I never said that. I just don't want him to have alcohol and I don't want him to go out in the middle of the night. That's it. I mean, bring him here. Let me talk to him. I'll give you a reasonable time past 9. I will. But I don't want him out at 12 or 1 in the morning. Just not with the 2 pending, you know, just.
Duly noted,
Does
Your
he have a
Honor.
scram monitor now?
He has a GPS. State, does he have? For once, it wasn't me. I've done it 3 times. State, do you know if he has a scram? I know he has I believe he does.
Or
have a
just,
scram.
we can figure it out later. Let me talk to him. I'll give you a little bit more time,
Okay.
okay?
All right,
But it's
Judge.
not going to be till midnight.
And another question about another case. Again, the client is not here today. It's on David Reyes. He has a DWI and a possession of a dangerous drug pending.
Okay.
In theory, Your Honor, would you hear a dispositive motion to suppress, or do
Yes,
you
of
carry this
course.
to trial?
No.
Okay.
Dispositive, absolutely, because that would dispense of the case, right? A normal garden variety motion to suppress, no, because then if
Waste time.
right, but dispositive, absolutely, yes. Okay, Mr. Dakota, hey,
Just get on one of those dating apps, have them there by 8:30.
how are you?
I'm good, how are you?
What's new?
Same
You're
old
getting a lot of airtime. You're a celebrity.
about all that, but
You are. Looks good. Try to have somewhat of a good time, you know?
I heard the bathroom's kind of. Judge, I have Myra Herrera on the docket. She has a DWI and last name is Herrera, Myra Herrera. She has a DWI and FSGI. The case is gonna work out, but trying to figure out restitution and if they're gonna.
Do you have, it's getting up there. Do you have a cooperative CW as far as restitution?
Your Honor, what's your client's name?
Myra Herrera.
Herrera. You know, lately, Mr. Dakota,
Yeah, I know he's cooperative. He's very cooperative on the scene.
okay. Yeah, totally. Do you, Alex, what's going on? How come you can't get the restitution?
Connor, it looks like a RIP was performed. It's just, I suppose she just didn't send the restitution amount. We could reach back out and get the restitution information, but we do have contact with her.
Okay, great. We'll set it off 2 weeks,
Judge, I'm gonna be out of the country. Can we do like 3? Thanks, Judge. Appreciate it.
3 weeks. Yeah. Hey, ready? Hi.
I have Juan David Cutts a bit on the docket today.
Cut, yes? Tell me. Whoa, it's 180 days. So if you guys want a PTI, now's the time. I'll give you 2 weeks. If he wants PTI, he's got to have all the documents in by the next setting, because then it'll be 200 days. We'll have him come in, we'll send him for a TRAS at that time. Are they approved, or does he need a mitigation packet?
He's approved right now. PTI on off.
So all you have to do is literally the application. It's just like just a couple pages you fill out and that's it. So if by the next 2 weeks, he's got to be here, whether you guys accept it, deny it, we'll set it for trial. If he accepts it, got to have the application in and we'll send it for a TRAS. Okay? All right. Thanks. Yes, ma'am.
No, he just walked in. Your Honor, I have a Spanish arraignment on page 4, Macero.
Okay.
Bob, good morning.
Yes, this Mr. Isaguirre's law office. Hey, Rick, this is Judge Fleischer in Court 5. Hey, he's got a client on Monday's docket, Mr. Martinez, that has bond violations. Can you just make sure that on that day, the defendant's here to answer for the bond violation, please? It's Monday. Yeah, he must appear. Thanks. All right, take it. Apellido? Macero.
Your Honor.
Thanks. Mr. Macero, you're charged with failure to identify oneself, giving false or fictitious information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to an attorney. If you cannot afford one, one will be appointed to you.
Just get a cause number for that real quick.
It's 2533067.
On October 8th, 2024, the officer observed the defendant's motor vehicle fail to stop at a stop sign. A traffic stop was initiated. The officer made contact with the defendant. The defendant stated he did not have a driver's license, ID, or passport. The defendant wrote Jesus Gutierrez, date of birth October 2nd, 1977, on a notepad provided by the officer. There was no TCIC return for the name. The officer observed the defendant's motor vehicle to have a different VIN from that on TCIC, and the defendant consented to a search of the motor vehicle. The officer found a Venezuelan passport with the defendant's photograph and the name Jairo Jose Macero Barcenas, date of birth January 11th, 1976. The defendant stated he lied about the name to the officer and used a fake name because he was afraid and had never been stopped by officers while in the country.
Mr. Marcelo Barcenas. Yeah, go. Thanks, Luis. Marcelo Barcenas, I'm going to find that there's probable cause to go forward with your case. Are you a United States citizen?
What?
Are you a United States citizen?
No.
Are you in this country with or without permission?
Without permission.
I'm going to give you a warning now that if you go to jail and immigration finds you, they will put an immigration detainer on you. You will remain in custody until this case is over with, and then you will be shipped off to immigration and you will sit in immigration custody until they do whatever they're going to do to you. That usually is a process that'll take about 6 to 9 months. If you do not want that to happen, do not violate any of the conditions that I put on you now. Because if you do, you could be spending a lot of time in custody. You do not have a Texas driver license, so you are not allowed to drive. I am making that a condition of your bond. The other condition I'm putting now is not to get in trouble or violate any laws. You were able, I don't know if you went to jail, but from now on, you will not be given any more PR bonds. So your bonds will be sufficiently high that you're going to spend some time there. And if you're unlucky enough, immigration will put a detainer on you. You will get no further warnings. Do you understand? No driving whatsoever. Okay. We are going to reset your case to give you time to hire a lawyer. First, I will have you come up here, swear to us that you're not going to drive. After that, I will get you to Victoria, where we will have you sign a reset, and we're going to get you out of here. These are the only conditions I'm putting on you now. Don't drive and don't get in trouble. When you come back, please have a lawyer, sir. Hey, Vic. Let's spread her on the docket again. Test positive for alcohol. See you Monday. Morning, Mr.
Good morning.
Hey.
I'm approaching on Javid, Javed. He's on docket for an arraignment today. I believe he's already come up, but he hired us. And so I wanted to talk about his bond conditions. The complaining witness is his wife and they're working on their marriage. She's already reached out to me. She
I don't
said she
know,
wants to
man.
contact, she even signed an affidavit of non-prosecution. I think no threatening and harassing would be suitable here, considering.
I don't know. I mean, sounding from the facts of the case, you know,
She was saying she didn't even want to press charges. She was saying that she didn't feel threatened, that this didn't happen this exact time, as it said.
I got the complete opposite from what I heard on the, I mean, it sounded like he's terrorizing her, terrorizing the family overseas.
Right, that's just a statement, though. I mean, the complaining witness can speak for herself and
Okay,
say.
yeah, I'll hear from her if she's here, but I don't think I'm prepared to let him talk to her at this point.
Yeah, Judge, so this case is with DVD. They have not been able to make contact with her yet.
I'm not gonna-
Yeah.
They've not been able to even make contact with her DVD.
Okay, can we try her today?
Well,
Because I spoke with her just yesterday. She already sent me over an affidavit of non-prosecution. She's reached out to me, so I think she'll be willing to talk to the state today.
I mean,
Judge, we're not DVD prosecutors here, and our DVD prosecutor is in trial right now. He'll give her a call as soon as possible, but the state does not feel comfortable just doing no threatening or harassing when we haven't made.
I understand that. I never, if and until I hear from the complaining witness, because I don't know what her wishes are. I know that she's giving you this stuff, but I don't know how it happened. Was it at some kind of undue pressure? I don't know. So out of an abundance of caution now, he's not to have any contact with her for the foreseeable future until I know.
Okay.
But it's not forever, but for now, you know,
Okay, and the DVD prosecutor is the only one that can reach out to her?
their case.
They need to be present, yes. Okay, we don't have any other ones that's not in charge? I mean, we would need to call someone else in, but no, the person that's assigned to this court for DVD is in trial right now. So is it
There may
possible
be
for us
other
to call someone else in?
prosecutors, but I don't know.
Okay, is it possible? We can talk about it over there. Thank you, Judge.
Sure. Did Durham check in? Durham is on the docket today. Guys, I'd like to send him for a drug and alcohol test right now, please. Hello?
Good morning, law office.
Yes, this is Judge Fleischer in Court 5. Is Mr. Reyes in?
He's actually, should be downtown, Judge Fleischer.
So-
You need him in your court?
No, but I have a client of his, Cabrera, who's got bond violations, and I need to put him on the docket.
Oh, okay. He'll be in your court today on Landa Verde, so I think it'll work out.
So I was gonna have the Cabrera on Friday. Are you guys gonna be here on Friday? Do you know?
He won't be there on Friday. He's got his trust test. He won't be working at all.
Monday?
Nothing on Monday. He'll be there Tuesday.
How about tomorrow?
Tomorrow, he'll be in court tomorrow. We can do tomorrow.
Okay, so would you let Mr. Cabrera know he's got to be here, please?
Okay, sure.
Do you need a cause number?
Oh, no, I have him.
You got it? Okay,
I have him. Yeah, I received his bond violation.
got it. Okay,
notification, So yeah, I'll contact him.
gracias.
All right, thank you.
Ciao, ciao.
Again, on Rudy Ochoa,
Okay,
he was able to bond out. They let him out this morning. He's here in court.
you mind bringing him up?
I'm sorry?
Do you mind bringing him up, please? How was jail? Good. You pick up another case, you violate conditions. Next time it'll be doubled, tripled, maybe quadrupled, depending on what happens. I'm not asking much from you. I'm asking you not to consume alcohol or illegal drugs and obey the law. And if you become a danger to society, there's only one place. Do you understand?
Sure.
Okay. Like I said, I'm not asking you to split the atom here. Just be nice. It's not hard. So bond condition so this is Ochoa Lacan.
Yes, Judge.
I'm letting pre-con know. So he's in the jail docket? Yes, page 29, guys. No drugs, no alcohol, random urinalysis. Alex, can you run his license to see if it's eligible or not?
Yes, Your
please?
Honor.
Whatever happened with the investigation that they were doing, do you know? With the interference?
I checked them, they didn't file anything, nothing new has been filed.
Alex, do we know anything about the investigation? Do we know any other further charges that are potentially going to be filed?
I don't see anything about the sexual assault investigation, so, and also his license is, I apologize, just closed out, not eligible.
I'm ordering you now not to drive. Your license has been suspended, probably due to the administrative license revocation hearing. So I'm going to have you sign an affidavit with me today, Mr. Ochoa. You're not allowed to drive. Do you understand? We had them check in the system now with DPS to see if it's eligible or not eligible. And it is not eligible.
And Your Honor, you are correct, it's the ALR suspension.
Do you understand? So if you drove here, you may not drive home. You've got to find someone else. Do you understand? You violate these conditions. Like I said, you're going to be signing an affidavit. This is a promise you're making to me not to drive. And I'm telling you, there's no better way to see me really get upset than to drive when there's a no driving affidavit. Do you understand? It is your responsibility to get with DPS to try to figure out how to get your license back. And if you do, and you get liability insurance, I'll take this off. But until that point, don't drive. So I will have you come up here, swear to us that you're not going to drive. We will have you sign a reset. After that, you'll pre-chop for your bond conditions, and after that, you'll be free to go. Okay.
Judge, if I may, he is here this morning on the DWI. The interfering is set for Friday. Is there any way we can handle
No.
both of those today?
Have you come multiple days?
Okay. come back on
Kidding,
Friday.
of course.
So
Yes.
are there gonna be different conditions for that or the same
No,
conditions?
it'll be all in one. That's why I was in the interference, I was wanting to see if there's a complaining witness to forbid him to have contact with, but it looks like the interference is just with an officer, so I'm not gonna put any conditions on that one. Everything, it just rides on the DWI. So you know what's expected of you. You're skirting thin ice. Be careful. That ice breaks. Okay? That way.
Thanks, sir.
Okay, take care. Oh, I didn't do it? Really?
How are you doing?
Good,
Good. We have Mr. Lorenzo Castillo on your docket this morning. Spoke with the state this morning. They are going to consider a counter offer of a deferred. They made an initial offer of a time served on this case. We'd like to try to get something worked out where he doesn't have to, I guess, fully take a conviction on his record for this.
How come no, I'm assuming he may have priors, is that?
That's correct, Judge. They were dismissed, but he nonetheless does have another, I believe, misdemeanor assault case. Yeah.
Right.
And so the state was able to rip the CW yesterday afternoon. And so we're kind of heading towards a resolution. I don't believe we need much time if we can just have a 2-week reset on this case. The state assured me they'd be able to get their evaluation done and see if they were willing to make a deferred offer by the end of the day today.
He's got to be here at the next setting, and then
yes,
we'll
sir.
make a decision, but it's either play or trial at the next setting, and then that's it. Okay, so
Yes,
2
sir.
weeks it is, and then we'll see you then.
Perfect. Thank you, Judge.
Okay,
May I be
take-
excused?
Yes, sir.
It's an off-docket matter, Judge, that's fine. Cause number is 252-2108.
Put her on the docket because she has bond violations. We put her on for Friday.
At our last setting, you admonished her about smoking marijuana, and you sent her to go get tested because you wanted to make sure her levels were going down. And so I think you got the BVR for that test. You admonished her because she was a young lady who had lupus and she had a marijuana card.
So
You already admonished her, and so I'm gonna test you today, and at your next court setting, I'm
so
gonna
she
test.
took another test 10/7, right? Is that what the issue, right?
At our last court setting?
No, it looks like she recently took another test and it was still positive for marijuana, but that wasn't enough time. You're right. So we can give you more time.
So you wanted me to put her on the docket for bond
But
forfeit?
we'll put her off more.
Okay.
Until after the 40th day mark. Okay, so let's just do that. And then if they submit another BVR, just remind me and then we'll,
Okay.
so we don't have to do this again.
All right.
So we'll just keep that one date that you had and then so she doesn't have to for Friday. Thank you, Mr. Stevens, for sure. Abel, you got my text?
Yes, sir.
Okay. You need me before I go?
No, sir.
You're right back. About 30 minutes.
30 minutes?
You okay? John D.
Judge, may I
Hey,
approach?
of course.
Judge, I'm approaching on young Miss Maria de la Cruz.
She's a theft. She already has her bond conditions and everything. We're waiting on some videos, Judge, so just a normal reset. Is that okay? All right. So,
He got appointed? No, or you say no?
well, on Dela Cruz, but I do have Mr. Johnson, so.
Okay.
Mr. Johnson is, got a bunch of stuff upstairs. There's a 5 years TDC that he just, needs some time to talk to his lawyers up there, Judge. I think the upstairs cases are reset to 11/20. I already have affirmation that they will dismiss our case as soon as that case up there. So can we go 11/21 or something after that? Okay, that's it then, Judge.
You think he's gonna take it that time?
He says he just wants to talk it over with his attorney.
It's really early too.
Yeah.
Right? I mean, it's only been three months. Yeah, of course. You got,
No,
He's talking about Johnson.
no, I'm just waiting for the video.